She was so afraid or had all this, concerns, and she should have been the one that filed it. And I was the one who filed it because I wanted consistency and I wanted this. And she's bringing up all this stuff from things that, like, there's no back to it. I mean, Talon's never been hurt. He's never been, had any kind of issues being with me. And I've had him a lot. And that's why I'm so upset, is because her and this guardian let him just like team up. And it's like, wait a minute, you guys talked to me for 5 minutes and I've never given any reason for any of this.
Mr. Yoko, did you read the guardian ad litem's recommendations? There is 4 main points of recommendations, and there's subsection 2 had four specific recommendations as to visitation. Do you have any position on those recommendations?
I haven't even read it. She's not told me about anything. I've been in the hospital. Other than that, I don't know what her.
Let me go ahead and share it with you, so you know what she's saying. She's recommending that Ms. Geyer have primary custody of Talon, including educational and medical decision-making authority, and recommending phased in parenting or residential time for Mr. Yokel. She indicates that her recommendation is that Mr. Yokel have professionally supervised visitation up to 4 hours weekly, and the supervisor notes would be submitted to the court and to Ms. Geyer, and that you would have to complete a mental health evaluation and comply with all treatment recommendations, and you'd have to submit for the evaluation and compliance reports to the court and to Ms. Geyer. Same for the substance use evaluation. Comply with treatment recommendations, submit the evaluation and compliance reports to the court and Ms. Geyer. And then it looks like Ms. Geyer fell off and looks like she's coming back in. So let's get her back in. Okay, Ms. Geyer fell off, but it looks like she's back in. I was just reviewing the recommendations from the guardian ad litem. And then once those aspects have been completed, then Mr. Yokel would be free to petition the court to phase in a lay supervisor or a non-professional and unsupervised visitation. So that's the recommendation from Ms. Turnbull.
Right. And what is her basis off those recommendations? I mean, what has been caused that would warrant something like that?
So let me ask Ms. Turnbull, did you provide a copy of that document of your report to Mr. Yokel?
I mailed it to him certified in priority mail, and he should have received it no later than yesterday.
Absolutely did not receive anything.
Okay. All right. Well, I think the approach we should probably take at this point, the motion to dismiss, it's number one, it's not properly before the court. The service was not given to Ms. Geyer, so she hasn't had an opportunity to respond. More so and more to the point, although any party can move to dismiss, once a case has been filed, the court has ultimate decision making as far as if a case is going to be dismissed. I think there's enough issues here raised by Ms. Turnbull in her report that indicates some concerns and issues related to substance use disorder and also mental health concerns, that it would be improper to grant that motion to dismiss. So I'm denying it. I'm denying that motion, and I've signed off on that order that denies the dismissal. So the case lives on and continues. Since Mr. Yokel has indicated that, Ms. Turnbull, you said you sent it certified, your report to Mr. Yokel. Sometimes you get those little green cards back. It's probably too soon for you to have received that back. Is that correct?
Yes, that's correct.
Okay. So Mr. Yokel's indicated that he hasn't read the guardian ad litem report. So it's probably best if we were to return to this once he's had an opportunity to review that with Ms. Turnbull's representation that she sent it certified and it's likely going to be delivered at latest either yesterday or today. We were to set this over 1 week. We could call this case at the top of the docket next week. Have a quick review again of the guardian ad litem report. Everybody will have read that at that time, and we could have a more full and conversation and finalize a decision on the recommendations. So that's what I'm thinking we need to do. So that's what we'll do. So we can take it at the top of the docket and let people get back, since we spent some time on it here today and people have other things to do. So Mr. Yokel will get a copy of that, and then we'll be able to respond and hear about the case from all parties. Thanks.
So I have a
Thanks.
question.
Yes.
So we're gonna set it over a week to have her report reflect 5 minutes that we talked. Is that what this is? Because you might as well just do it now. I mean, what's the point of waiting a whole nother week just to sit over, for her to give 5 minutes of her talking with me?
The point of setting it over is giving a
Yeah.
notice and opportunity to be heard. So you indicated you have not received the report. I think it's
What does it matter?
that you read the report.
Obviously, it doesn't
Be
matter.
aware. Don't interrupt me, Mr. Yokel.
Well, obviously, it doesn't fucking
Mr.
matter,
Yokel, do not interrupt me. Do you understand that?
dude. This is fucking bullshit.
Mr. Yokel, if you swear again, I'll hold you in contempt. Do you understand that? I'm warning you. All right, took care of that himself. Thanks. We'll see everybody next week. Next matter I have is Tiffany Hall and Joseph Sorensen. This is cause 19-3-393-08. And bear with me just 1 second. And it looks like Ms. Hall her name has changed, so it's Tiffany Fike. Is that correct, Ms. Fike?
Yes.
Okay, all right. I apologize for that.
That's okay.
And so you're present. Welcome to you. And Mr. Sorensen, are you on the line?
Yes.
Okay, all right. Welcome, Mr. Sorensen. All right, today it looks like we're on for two separate matters. One matter is Mr. Sorensen's motion for contempt related to the parenting plan. And then Ms. Fike has filed a motion for adequate cause and a motion to modify the parenting plan related to the 14-year-old son.
Yes.
So what I'd like to do first is address the contempt motion first. So Mr. Sorensen, you're the moving party in that motion. So you can lay out. I've read the pleadings that both parties have submitted, and they were not short. So I read all of them last night. So I read everything that you have submitted. And so I'll hear from Mr. Sorensen first, and then we'll hear Ms. Fike's response to the motion. Mr. Sorensen.
Your Honor, I'm here today to hold Ms. Fike in contempt to regain my
Oh, Mr. Sorensen, I apologize to interrupt just as you guys are going.
Statements what I filed and asked for. The parenting plan is not.
So, Mr. Sorensen, when
Yeah.
you first started speaking, your audio was terribly garbled, and it was just little bits and pieces, and then it started speeding up and kind of putting everything together again. So I missed pretty much everything that you said at the beginning.
Okay. Basically, I'm here for contempt as the parenting plan was not obeyed. The violations were all.
Oh, Mr. Sorensen, sorry to do this to you again. It looks like we're having that same audio issue. What I found in the past, sometimes
denied visitation on
let's give
6/25,
this a
6/26,
try. Mr. Sorensen, would you mind shutting off your video? Sometimes that decreases the bandwidth sufficiently that just allows the audio to come through nice and clear without the distortion that I'm hearing. Okay, let's give that a shot. And I apologize if you want to give it a third try, go for it.
The visitation 6/25, 6/77.
Oh, I'm going to interrupt
Ms.
again,
Fike,
Mr.
start.
Sorensen. I apologize. The quality is slightly improved, but it's really hard to hear. I'm wondering is there a different device maybe that you could zoom in on and see if that has a better connection, or maybe just disconnecting and reconnecting? Because right now it's exceedingly hard to understand. Mr. Sorensen, can you hear me?
Yeah.
Okay. Phone seems to be working a lot better and it's much more clear. So I'm ready to hear your comments related to your motion for contempt.
Your Honor, I'm here today to hold Ms. Fike in contempt and regain my residential schedule with my son. As you can see from the filed statements, what I have filed and asking for. The parenting plan was not obeyed by the mother, and the violations are as follows. Did not follow the residential schedule in Section 8, Paragraph B. I was denied visitation on 6/25, 6/26, and 7/7. Ms. Fike disparaged the parent myself in front of the child, which occurred on 6/25 pickup day, which violates Section 14, Paragraph restrictions in the parenting plan, where she discussed adult issue matters, badmouthed me and my wife, and slandered me, used profanity towards me, refused my visitation, and kicked me off her property in front of our son. She asked the child involved to make decisions or requests involving the residential schedule with which violates section 14 paragraph restrictions. Ms. Fike and our son clearly discussed changing the residential plan. Ms. Fike requests our son to discuss and to make a decision on attending visitation where he chose not to. She discussed changing the residential schedule with our child outside of already agreed plans, which violates section 14 paragraph restrictions. She encouraged the child it was his choice to change his primary residence and his choice whether or not he attends, which violates section 14 and the paragraph restrictions. She did not construct a regular and consistent responsiveness and cooperation during refusal of visitation, which also violates the section 14 with restrictions. Tiffany did not attempt to reach me in any way on June 25th to discuss, resolve, or inform me of any disruptions to the schedule, even after being instructed to do so by LPD. She tells my child he does not have to attend visitation, that she is not going to make him, goes and files a plan for supervised visits, and tells me he should stay with her until the 20th. Then, after being informed of contempt, states she can't physically make him go. That contradicts all her claims and that she is following the parenting plan and keeping him from me. Ms. Fike did not notify me prior to pickup to inform me of Christopher's refusal. She had hours to do so and did not. She also did not discuss any resolutions with me, asked me to get help Christopher to attend, did not ask the police to enforce their help, did not ask me to attend a conversation at pickup time. Instead, she had Christopher contact me, inform me he was not attending visitation 4 hours before visitation was to occur. She had plenty of time to contact me during the 4 hours before pickup time to occur and didn't. I attempted to contact Ms. Fike and she denied both phone calls, which puts our child in decision making. I had no choice but to contact LPD for help. LPD then contacted Ms. Fike when she answered for them, and she was instructed to follow the parenting plan and to make sure my son came home, and was also instructed to contact me. Neither one occurred. Ms. Fike never made contact with me. After being informed by Christopher he was not to attend visitation and speaking with LPD, I attempted to pick Christopher up that evening. I was met at the door with Tiffany trying to facilitate an ambush against me in front of my son and Coach Christopher, not once telling Christopher he is to attend visitation and go with me, or to get in the car, which should have been the only issue we were discussing. Instead, she was allowing my son to tell me he is not attending and he shouldn't have to, with his mother in agreement. That she's not going to make him. Christopher was disrespecting me and defying my wishes to get in the car. She also instructed me to read a letter Christopher wrote to the courts, not to me, but to the courts. I read the first few lines and it was talking ill about me and my wife and tired of having to obey our rules, again placing him in the middle of involving him in court decisions. She wanted to control the narrative and shame and slander me in front of our son. It was in a non-constructive environment, not suitable for any discussion. I ended up being told by Ms. Fike to get off her property and to leave without my son. I tried the following day to get Christopher and was met again with text from Christopher that he is not attending. I tried calling Ms. Fike, who did not answer, and received text that she is not going to make him. I tried to regain my visitation on the second week I was to have Christopher. I set up counseling for him to attend and tried to contact Ms. Fike that Christopher needs to attend visitation. She did not want to hear anything about it. She refused communication about the second visitation to start on 7/7. I did not in any way approach Ms. Fike combatively or maliciously. I simply informed her Christopher needs to come home, attend counseling, and offered a non-conflict way to get him home. She ignored my texts. The following day, however, she threatened harassment charges on me if I were to continue talking about receiving my son. She told me we needed to wait for court and that Christopher should remain with her until then. I contacted LPD, who tried to get Ms. Fike again to follow through with the parenting plan, mentioning multiple times it's in her best interest to do everything possible to follow the parenting plan, and she told them as well she was not going to force Christopher to go. LPD then instructed me to continue with the contempt. She supports any and all alienation of involvement and sees no issue with it at all. Ms. Fike, in the midst of this, used her personal server, be that of her mother, Jill Hall, the grandmother of Christopher, who for the better half of 3 years, it was ordered by the courts she is not be around Christopher until she can attend drug counseling and pass a hair follicle test, since she is a known drug addict and has placed Christopher in danger in the past. A woman who is not allowed around my son should not be allowed on my property or near my family. Jill Hall came to my residence twice, both times relentlessly banging on my door and ringing the doorbell for over 5 minutes at a time. Jill Hall is a very dangerous and unpredictable individual that should not be involved in this situation or around in any form. I told Jill Hall when I retrieved the papers to not come back to my property, where she then screamed, "You've been served." Ms. Fike utilizing her mother in this situation is very concerning and puts our family in danger, which only solidifies malicious intent. The constant problem at hand is Christopher feeling pressured and coached to evade my house. He is discouraged from loving myself or a lifelong bonus mom. Christopher voices this time and time again and asks for help on the issue. Every 2 to 3 years, Tiffany tries to find ways to manipulate the courts and change the schedule, use baseless false accusations to attain that. This case is consistent with the previous ones. Christopher displays the same antics at our house, however, it is handled appropriately. Christopher voices major and concerning issues about his mother's home weekly. So we utilize the school counselor when he has an issue. We set up a meeting there to discuss it. We don't ambush Miss Fike or harass her via text, name call, disrespect, or make Christopher feel he has to choose. We pick a professional setting suitable for all parties involved. Your Honor, Christopher refuses, he does not want to attend his mother's visitation almost every week and voices concerns on Fridays. However, we encourage him to spend time with his mother, tell him he is to attend. We run through problem solving, give him problem solving tips. We do not keep him home from her or make him choose to involve him in the court matters that are trauma causing. We always try to facilitate a constructive in-house resolution without slandering Tiffany or causing Christopher to fill in the middle. I myself initiated and asked the court's last custody case to hire a GAL to help with the ongoing issue. I knew involving a professional who works to find the truth would, and she did. Rhonda Larson did an amazing job. She is also available to call on as she is still on our case. I also have been working with the school counselor and Christopher about this exact problem Christopher has with his mother making him to choose sides, lying about my wife and myself, making false allegations. I also attained an outside counselor outlet for Christopher through the school council to help with these issues at Northwest Psychology. I cannot comprehend how Ms. Fike thinks complete annihilation of our family is a good plan. She feels the need to constantly destroy me, my wife's relationship, and family. She uses Christopher in order to do so, not realizing she's destroying him in the process. Christopher has been forced by his mother to write letters, make false claims, and statements about my family, which I know fills Christopher with guilt and embarrassment, as he states. A time my son should have been spending with myself, attending youth group, Christ for the Court basketball camp, collecting his volunteer hours for high school. We have scheduled on our time, attending his job he acquired, family vacations, 2 of which were canceled due to these circumstances, missing a sister. Instead, he spent a better portion of almost a month away from me with no communication at all, under the impression he is prepared to take his father to court. Stressed, sad, and unequivocally involved in adult matters no child should, my son has never gone 3 days without talking to me or 7 days without seeing me in his entire life. While I've been dedicated to following the instructions of the court and parenting plan, Ms. Fike has been creating an environment of paranoia and fear for Christopher, taking him away from his family and disregarding the instructions set forth by the courts and law enforcement. I'm asking the courts to bring my son home immediately for the lost time to be awarded, where he needs to attend counseling, get back into his schedule he lost, and attend his youth group, prepare for school coming up. He desperately thrives on this schedule that has been robbed. I'd like Ms. Fike held accountable so this situation is to never occur again. Thank you.
Okay, thank you, Mr. Sorensen. All right, Ms. Fike, I'll hear your response in relation to the motion for contempt, please.
Yes. So, like you said, this is my 3rd attempt to change the parenting plan. Well, 3 years ago, my son threatened to run away. He's threatened to run away from his dad's house multiple times due to mental and emotional abuse from his dad and stepmom, and more so physical, as you know, Mariah has pushed Christopher before. The reason why I've put this motion into place, because Sunday, June 25th, we got home from my sister's house. It was my nephew's birthday party. He was to go to his dad's at 8 p.m. At 6 p.m. that night, he comes to me or calls me into his room and says, "Mom, what would happen if I refused to go to my dad's?" Is he muted? What would happen if my mom, or if I refused to go to my dad's house? I told them, I'm not sure what would happen, but why don't you want to go to your dad's? Like I said, this was 6 p.m. It was 2 hours before he would have went to his dad's house. I'm talking to him about it, why he doesn't want to go to his dad's. He says the same reason for years. He said he was in the middle of writing a letter to the courts. I did not persuade him. This was This came out of nowhere that he refused and wants to write a letter to the courts. Did I submit that letter? I did not submit that letter. He wanted his dad to read it because everything on there pinpoints the majority of what's been going on and how he feels about it. My son is mentally and emotionally abused over there daily. He's never wanted to go to his dad's house. He has blatantly said it every single week, but this is the first time he's actually refused to go. I told him I'm not going to make him, but that he needs to go. I feel like he does. But in the back of my mind, from what's been happening over the years, that nobody's been listening. Like, I feel like this, like I said in my declaration, this is his final cry for help. I'm hoping he wants to talk to you, the judge. He wants his voice heard, not what, because the back and forth saying what Christopher says at his dad's house and what Christopher says here, like somebody else needs to be that middleman. And as of counseling, I didn't hear about him putting him into counseling until, let's say, I didn't get served with his papers till the 4th of July. And that's when I read that he had an appointment at Northwest Psychological, which we both should have been informed on that as well. And then the next day on July 5th, Joseph texted me and said that Christopher will be going to that appointment, that he made this appointment, this and that. Well, I already also made him an appointment at Core Health. He has an appointment on August 1st at 1 p.m. Christopher filled out the intake. Christopher filled out all the questionnaires as it's his counseling session, and he turned it in. So my question is, why or how did he get that appointment with psychological without talking to Christopher about, or having Christopher fill out the child intake? Because that's what that other courthouse says, it's for him. Since he's over the age of 13, teens have a little bit more rights than parents know of. And I said, okay, that makes more sense. So I read the child and intake form that would have been filled out for psychological. And one of the questions were, for you as a parent, why do you think that your son needs counseling? Well, I'm not sure what they put on that piece of paper, but my son is refusing to go to his dad's house. So whatever they put on that paper is what they're telling you. So my thought is Northwest Psychological already has a different version of what Christopher's really going through because his dad wrote whatever he did on that paper. The intake that Christopher filled out for Core Health is all of his words, all of his answers, all of everything for Christopher. I didn't even read it. I just took him to turn it in. Like all that is, I didn't read it because I want people to realize I'm not the one making him do this. I'm not the one bringing court into him. I'm not the one who's bringing any of that up. Christopher is pretty much fed up. And what happened at the airport after his DC trip with his stepmom, I think that might have been the last straw, because it's just too much. I'm really hoping that somebody's actually going to listen. It's not me holding Christopher away from his dad. It's Christopher refusing to go. As my part, yes, I should force him. I'm not going to physically force my son to go somewhere where he's not safe or doesn't feel safe until somebody else says so, which I feel counseling is going to make that tremendous leap, and or talking to the judge or getting that input, because Christopher is suffering. He's almost 15 years old. We've been going back and forth to court since he was little because of everything Christopher has told me, and everything I've written is what my son tells me. I believe him 100%, regardless of what people say that he's embellishing stories to get the parents to believe what they want to believe. That is ridiculous, because he's still refusing to go. With Joe saying that they haven't been any contact, Christopher has a phone. He hasn't even tried to contact his son to even ask him why he doesn't want to go. He still hasn't asked him why. He could have put that effort into talking to his son too, because he has a phone. But regardless, I've never ignored his text messages. All the police says their advice is to go with the parenting plan, and I told them I was doing that as best as I can. 6 p.m. is when Christopher brought that up to me about refusing to go to his dad's. I get a call from LPD by 6:20 because Christopher also says, oh, and I text my dad I wasn't going. I never told him to text his dad. He did that all on his own. 6:20, no, around that time, Joe calls me. I didn't answer because I was in the middle of a discussion with my son, trying to figure out why he doesn't want to go, because he had till 8 p.m. to go. So I'm trying to talk to my son. So then he calls the police and says, I'm not responding. So the police call and I explained to the officer, yes, that I didn't answer his phone call because I'm in the middle of talking to my son about why he doesn't want to go to his dad's house. So that shouldn't be put on me because I didn't answer his phone call. I'm trying to get down to the bottom of it. And he just, nobody's listening. I don't know. When he came over after, him, Christopher saying and not going, Joe shows up around 7:55 that evening, demanding Christopher to come out. Christopher's sitting on the chair. He would not come out of the house. I'm like, Christopher, you need to get up. Christopher, you need to come talk to your dad. It took my husband telling him, Christopher, you need to get up. Go talk to your dad. He got up, went to the door, did want Christopher to read that, or Joseph to read that letter that he did write. He did admit to the police that he only read the first sentence or two, and nothing was slandering or anything about anybody. He didn't even get to read the letter. And with my mother, who's, yes, it's been 3 years since 3 years ago, Joe and Mariah brought my mother up in our custody case for some weird reason, because my son and my mom are inseparable, inseparable. My thought is they brought my mom up into my court case because they didn't have anything to go against me. Long story short, Judge Basher ordered for her not to see my son in person. They can still contact, FaceTime, and talk on the phone until she does what she was supposed to do, which I did submit the hair follicle tests and stuff too. I'm hoping to address that at this court date as well. My mother has always been the person who serves for me. That has nothing to do with my malicious intent, because I don't have anybody else willing to go over there because of how they are. And my mom's the only one willing to do it, then I need to serve. And I'm not going to pay $40 for a sheriff to do it because that's ridiculous. My mom banging on their door 5-10 minutes at a time, that's because you're not answering and she's trying to serve you papers. Long story short, everybody is trying to pinpoint all this on me when I hope people open their eyes and realize my son is in not a very good place. He's very sad. He's depressed. He wants people to listen. He's tired of nobody hearing his story.
All right, thank you, Ms. Fike. I appreciate your input. What I'd like to do now, I want to hear from each party on the motion to modify and the motion for adequate cause that has been brought by Ms. Fike. So Ms. Fike, if you want to address your motion, then I'll hear from Mr. Sorensen, and then I'll give you a ruling on both motions. Ms. Fike?
Yes. My order on adequate cause. Let me find my paper. Has, with my son refusing visitation at his father's home, he's tired of nobody listening. He's scared. He uses the word scared. He doesn't want to go to his father's house. I feel like either limited time or supervised visitation needs to happen until a counselor or somebody can actually open up their mind to listen to an actual 14-year-old. I don't know.
Okay, any additional input other than the pleadings and then those comments that you made there?
No, I mean, I'm sure there is. I'm just, there's a lot. I'm drawing a blank and I apologize.
Okay, it's okay. I read your pleadings and I read Mr.
Thank
Sorensen's
you.
pleadings. So, Mr. Sorensen, I'll hear from you on the motion for adequate cause and modification of the parenting plan.
Well, as right now, I am in the middle of trying to seek counsel for that. I have a meeting on the 15th. Is the soonest that I could get in to talk to counseling about, or to an attorney about if I need to acquire an attorney for that or not.
Yeah, the motion is properly noted for today, and we're hearing the motion today.
Okay. And then can I go back as far as the counseling that I have set up for him on the 26th?
You can
I
touch
did
on that.
not-
You can touch on that briefly. Go ahead.
I did not give an intake. The appointment for the 26th is for Christopher to go there to do the intake. I didn't answer any questions or anything. I made the appointment for him to go to there to do the intake. So I just want to make that clear that I didn't answer any questions for Christopher or spoke for Christopher. I just simply made the appointment for him to go and to do the intake himself.
Thanks. Okay, do you want to address the motion for adequate cause and modification?
As far as the adequate causes, I feel that this has kind of been an ongoing thing, as I stated in my statement for the contempt. I mean, I've hired a GAL. The GAL has you said you've read through it, so you've read what her report. We're kind of running into that same thing to where Christopher is playing both sides.
So just so you're aware, Mr. Sorensen, I did not read all 222 filed documents in the file. I read all applicable and relevant motions related to the two motions today. So I see that Ms. Larson filed the guardian ad litem report back in January of 2020. I have not reviewed that.
Okay. She had found what her findings were is everything that I'm stating, that Christopher was found to have to choose sides over at his mother's house, and that he is involved in adult conversations and in these court matters. I feel like, I mean, that's all we have is Christopher's best interest. And right now, I have a lot of rules. I mean, I hold him accountable, and he gets away with a lot more at his mother's. So it's kind of Disneyland versus somebody that has, I have rules.
Okay. All right. Thank you. Okay. So at the outset, it's, Christopher is, he's at a really interesting age. He's 14. It sounds like he's almost 15 years old. And it's a tough place to be as a teenager. Number one, it's a tough place to be for a teenager caught between two homes with different parenting styles, it sounds like, and different approaches to parenting. So here, the motion is brought by Mr. Sorensen for a motion for contempt related to the June 25th visitation. The parenting plan calls for a 50-50 plan, roughly. Well, it's a 50-50 plan with exchanges on Fridays. It sounds like the parties have kind of modified that a little bit to make it easier on them for whatever reason. So that's the motion. The indication is that Mr. Sorensen indicates that there was a refusal of Christopher to come to the visit. There's an indication by Ms. Fike that Christopher has some thoughts about what's happening, what he wants and what he doesn't want. And there's an indication that there was not a clear push or edict, if you will, or direction from Ms. Fike that he needed to go with his dad. Her focus tended to be more on listening to what he had to say. Dad's focusing to be more on there's a parenting plan and we need to follow that. So these situations are challenging because both parties have a lot to say. And I think that was noted by the variety of pleadings that were filed by the parties. And there's a lot of information that needs to be heard. So the issue is that there's a parenting plan. The parenting plan says it's a 50-50 plan. Life is not static. Children change, parents change, and the court system is kind of slow to change. We're not the most nimble of organizations. And so when there's a change, there's a feeling of immediacy. We need to make a change quickly. Things may have been brewing for some time with Christopher, and may have been thinking about some things for a long time, but it kind of came to head on this June 25th date. The difficult part is accommodating that and accommodating the parenting plan. There's kind of a natural tension there. So what needs to happen is that there's a court order. The court order controls. The parties have been unable to come to an agreement themselves, and so they've turned it over to a third party, the court, to resolve and guide the issue. So the court said those parenting plan needs to be followed, and the parents are to make sure that it happens. And 15-year-olds, certainly you can't pick up a 15-year-old or 14-year-old and pick them up and put them in a car. Not going to happen and would be inadvisable. There's other ways to persuade and encourage. And so I will make a finding of contempt. I think there was a clear indication, whether it was stated explicitly, I think it was the implicit message was clear. I'm not forcing you. You don't have to go. I don't think those words were specifically said, but I think the message came across clearly to Christopher that he did not need to go. And it was more important that his father engage with him, listen to him. And the parenting plan indicates that when I looked at that earlier today under paragraph 14, it says the following. I think this is important to note, where it states, each parent agrees to encourage the child to directly discuss with the parent in question any grievance they may have with that parent. I think that was appropriate. Ms. Fike indicated that Christopher had written a letter and he had wanted to share that with his dad, and it sounded like she encouraged Mr. Sorensen to speak to his son about that issue. It also indicates it's the intent of both parties to encourage a direct child-parent bond of communication. So that's there. So what I'm going to do, I'm going to impose a $100 civil penalty that contempt can be purged by following the parenting plan for 6 months or until there's a change in visitation. So I also think, and both parties recognize this, that Christopher needs some support through counseling. Sounds like both parties are cognizant of that and working towards that end. That's encouraging and good. And both parents can provide input to the counselor for the benefit of the child. So there's 2 counselors. I don't know if I need to rule on which counselor is going to go, who Christopher is going to attend with. A lot of counselors, it's a personality fit, and sometimes it's you meet with one counselor and it's just not a good fit. So I'm going to leave it to the parties to figure out which counselor he goes to, but he needs to be seen by a counselor. He needs to have that outlet. I'm also going to order this because I think both parents here have a lot of information to share, and there's a lot bottled up that's just needs to come out. So I think I'm going to require both Mr. Sorensen and Ms. Fike to engage themselves with the counselor for at least 3 sessions to discuss how your actions contribute to the situation. It's going to be a self-focus, self-reflective to better determine how you are contributing to the issue. I'm also going to require, I'm going to appoint a guardian ad litem. So the guardian ad litem can interview and speak with Christopher so his voice can be heard. And then both parents can have their opportunity to be heard also. That guardian ad litem's duty is simply that, to address the issue of a 14, almost 15-year-old boy as far as residential schedule. That's the sole focus. And to make clear that Christopher is not allowed to make the decision of where he goes. He's required to go as the parenting plan requires, and he should be disavowed of that false notion. It's gonna be a lot slower than a 14-year-old child wants things to happen. But we're going to get input from the guardian ad litem. He'll have an output with the counselor. Both parents will have opportunity to do some self-reflection under the guidance of a counselor to see how they're contributing to the issue, because it doesn't happen in a vacuum. And sometimes it's hard to see that without the professional help. So that's the contempt motion. As far as the motion to modify and the motion for adequate cause, I'm making a finding that there is not adequate cause at this point. So I'm denying the motion for adequate cause and denying the motion to modify the parenting plan. So with that said, I'll ask the parties if you have any questions or clarifications of the court's ruling.
As far as my lost time of the 2 weeks that I missed out on, is that just chalk that up as?
Yeah, good question. I thought about that, and I think under the current circumstances, I'm going to let that ride. I'm not going to order makeup time. I am requiring that the parenting plan pick up this Friday at the Friday or whatever. If it sounds like it was Sunday, maybe what the parties had kind of agreed on. But the parenting plan, if the parties can't agree, it'll be Friday at 5 p.m. That's when the exchange needs to occur. If the parties had been doing a different schedule, you're free to do that, but it has to happen this weekend. the exchange needs to occur.
Okay.
Ms. Fike, do you have any questions or points of clarification?
No, not at this time. Well, actually, when will we hear about the guardian ad litem?
Yeah, thanks. So I'm going to ask the guardian ad litem to do an accelerated review with a review in 30 days is my hope. And for guardian ad litem, that's a pretty quick turnaround time, and we'll have a hearing in roughly 30 days. And so let's go ahead and look at the calendar now and see what we have.